Good afternoon, and good morning, and good evening, depending which time zone you find yourselves in. Thank you for joining this webinar entitled The Role of MSIs, Multi-Stakeholder Initiatives in Ensuring Human Rights Due Diligence on the Private Security Supply Chain, which inscribes itself into the 14th OECD Forum on Responsible Mineral Supply Chains. This partner session is co-hosted by the Voluntary Principles on Security and Human Rights and the International Code of Conduct Association. As we approach 10 years of implementation of the due diligence guidance for responsible mineral supply chains, this panel considers a critical component of any mineral supply chain, that of private security. Indeed, private security providers are a key supplier for mineral companies. Private security personnel often act as the interface between mineral companies and the communities in which they operate. They secure mining sites, protect mineral company personnel, and enable their operations, often in complex and challenging environments where the rule of law is weak and state support can be lacking. Contracting and using private security providers that meet international standards, that respect human rights and international humanitarian law, is essential for any responsible mineral company. Obvious questions then that this panel will start looking into are: how should mining companies and end users conduct human rights due diligence on the security providers? How can responsible mining companies and their end users be confident that the contracted or in-house security personnel will be vetted, trained, fairly paid, fairly treated, and conduct themselves to the same high standards they expect of their employees? This session will look at the role of the Voluntary Principles on Security and Human Rights and the International Code of Conduct for Private Security Providers Association in providing effective human rights due diligence mechanisms to ensure that the private security providers contracted by mining companies act responsibly. The session will also consider how these mechanisms can future-proof responsible mining companies given the rising calls for mandatory human rights due diligence of multinational corporations' supply chains. Reflecting on how human rights due diligence is beginning to share the stage with other non-financial reporting of environmental, social, and governance issues, the session will demonstrate how human rights mechanisms, such as the Voluntary Principles Initiative and ICoCA, are more relevant than they have ever been. As Executive Director of ICoCA, I feel that this panel is timely. Through our work as a multi-stakeholder organization based in Geneva, Switzerland, we work with private security companies in high-risk and complex environments to ensure that they operate in compliance with the 2010 International Code of Conduct for Private Security Providers. And clearly, since the establishment of ICoCA, we are seeing a growing awareness by stakeholders across various sectors that more needs to be done in strengthening management, human rights due diligence, and oversight of private security providers along supply chains, and with noticeable pressures on clients, investors, and shareholders to step up in this field. We have also seen an increase in litigation against corporate entities in a variety of sectors, including diamonds, food and wholesale, agribusiness, oil and petroleum. At the international and multilateral levels, we're also seeing increased attention being given to the impact of private security on human rights. I'll finish with this quote before giving the floor to the panelists. But in a recent UN Working Group on Mercenaries report, there was a particular focus on the use of private security companies by the extractive industry. This is what they said: private military and security companies are among a number of actors providing security services to extractive companies, amid generally complex and opaque security arrangements within the industry. In this context, they have been known to directly commit human rights abuses, as well as to facilitate abuses and violations committed by others, working under contract from extractive companies and sometimes alongside state security forces. The working group is concerned over the lack of transparency with regard to the actors engaged in securing extractive operations and their respective roles, responsibilities, and chains of command. Hard-hitting conclusions by a working group looking at security, supply chain, responsibilities, and transparencies, and a whole range of issues to unpack. So to unpack these issues and to offer their insights and recommendations, we are joined by four great panelists, each of whom will bring a different perspective to the issues: government, MSI, security, and client. I won't take too much time introducing them, but instead turn to the first speaker, if I may, Maura Johnson, who's head of Secretariat of the Voluntary Principles on Security and Human Rights. I have a quite direct question for you as someone who heads another multi-stakeholder initiative, and specifically on the voluntary principles. So Maura, could you tell us in a few minutes, how can the voluntary principles on security and human rights help companies and their downstream partners ensure that private security providers engaged in or around mining sites respect human rights? You have all the solutions in about 5 minutes. The floor is yours.
Thank you so much. It's a great pleasure to be on this panel. Thanks so much to the organizers and to the OECD. The moderator's question goes to the heart of the voluntary principles. So I'll say a few things briefly about how the voluntary principles on security and human rights, or VPs, can help with this, about best practices around contracted and in-house security, and also be a little bit about the value of being a member of the initiative, the VPI. Then I'll say a few words about human rights due diligence in supply chains, all within about 5 or 6 minutes, so it'll be quite high level. The basic framework of the VPs is regularly conducting risk assessments, followed by careful planning and implementation of policies and procedures to mitigate those risks. The risk assessment would consider security risks, including harm to personnel and company assets, as well as risks of human rights violations to external stakeholders, such as local, community, and vulnerable groups. Risk assessments should include things like identification of risks related to political, economic, civil, or social factors, potential for violence, human rights records of relevant actors like public and private security, the local prosecuting authority and judiciary's capacity to ensure accountability, conflict analysis with identification of the root causes of conflict and level of adherence to human rights standards, and risks associated with the transfer of lethal and non-lethal equipment to security providers, and indeed risks related to those providers themselves. In order to mitigate those risks, companies need well-executed policies and procedures. And some of these, again, are outlined at a high level with the VPs. Companies should have human rights policies and security procedures that set out appropriate conduct, including the use of force. Only preventative and defensive services should be provided. Allegations of human rights abuses should be investigated and monitored. Individuals implicated in human rights abuses should not provide security services. Security should investigate and report all incidents in which force is used. And for the entire life cycle of the project, it is important to conduct regular community consultations and seek to understand how security arrangements impact community members, including women and vulnerable groups. When it comes to contracting private security providers to complement in-house providers, some best practices have emerged. Of course, certification by ICoCA, the Code of Conduct, is an important indicator of professionalism and human rights compliance. When contracting security providers, companies should set out clear human rights policies and expectations in their contract agreements with private security providers and make these contractually enforceable. Security contractors should be subject to the same policies, procedures, rules, and training regime as the in-house employees of the company. It is also important to do due diligence on the security company that you employ, including things like labor standards, pay and benefits. Are these on par? Vetting of individual security providers, ownership management, internal policies, and so on before contract formation. What role does the Voluntary Principles Initiative play in supporting the implementation of the VPs? Maybe I'll just briefly say that the initiative is a multi-stakeholder group of companies, governments, and civil society that focus on engagement, peer learning, sharing of best practices, and they help members effectively dialogue with relevant stakeholders, community, national, international level, NGOs, human rights organization, governments, community members, and so on. And this really enhances the risk assessments analysis and improves collective problem solving. I should mention that the VPI supports a number of in-country implementation groups which meet regularly to discuss security and human rights issues and work toward improving trust and finding mutually agreeable solutions to problems on the ground. And lastly, I'll mention that every VPI member submits an annual report outlining its implementation and undergoes a verification process, like a peer review, every few years. And the annual reports are made public. Now, turning to the issue on supply chain due diligence, how can downstream companies such as smelters, refiners, and manufacturers ensure or verify that mining companies are respecting security-related human rights? Well, I would start with the publicly available information from the company website, or better yet, look at our Voluntary Principles website to see members' annual reports, which are typically more detailed. Important things to look for would include membership or adherence to the voluntary principles, and/or, most importantly, relevant policies, procedures, and practices around security and human rights outlined publicly. Many of our members report on company procedures to conduct security and human rights risk assessments and how they integrate those findings and risks into their procedures. Look for a company's assessment of their compliance with the VPs or other standards, and whether the company performs a third-party audit of implementation, which more than 50% of our members do. Auditors typically pick challenging operational environments from among a company's operations to review and help that company improve their implementation. Look carefully for company reporting around community consultation and how much care and attention is given to this topic in their public reporting. Another issue to consider is whether the company has an operational level grievance mechanism, whistleblowing mechanism, or both, and whether it provides some information on this publicly, including possibly cases. So in short, if someone in your supply chain is a member of the VPI and/or they're having credible third-party audits or assurance of their implementation, if they're engaged in robust reporting, which is clear and detailed on their policies, procedures, grievance mechanisms, and other elements, if they report on problems and actions taken to improve their human rights practices, then downstream companies can probably feel very good about that company's respect for security-related human rights. I should also say that a company proud of its security and human rights policies would be pleased to talk about them and answer questions, particularly about challenging environments and lessons learned, which we do have a panelist today who will do just that. So 5 minutes is very brief to talk about these topics, and I hope I haven't been too superficial, but I'd be very pleased to pick up any of these elements in the question and answer session. Thank you.
Thank you very much, Maura. I mean, it's the 5-minute introductory comments can be tough to try to catch all key elements, but I think certainly the elements I liked, no doubt we'll sort of unpack it a little bit later on. There's that question of the verification, the monitoring, the auditing. Previous panels during this forum highlighted the question of transparency, but they were also looking at that kind of impact. The fact that it's nice to have policies, but to what extent are those policies being verified, and to what extent are they being fully implemented? And we know from the side of the association that monitoring of private security companies going in country, working with them is essential to give that kind of level of confidence and assurance. But in high risk and conflict environments, that can be quite testing and exercise. And so it'll be interesting when we look at maybe how civil society organizations have a role to play here. We could discuss that. But I'll come back to you more after everyone else for sure. If anyone from the public has any questions, please put them in the chat. We'll try to get to them directly or in writing as well. So that was sort of the MSI perspective. I will now turn to a government perspective and invite Frédéric Chenet, who's a senior advisor, Federal Department of Foreign Affairs, Peace and Human Rights Division here in Switzerland. And if I'm not mistaken, Switzerland are both a member of the International Code of Conduct Association as well as the Voluntary Principles Initiative. And so quite committed, or very committed, to ensuring that there is responsible mining along the supply chain and human rights respected. So question for you, quite direct, Fred, if I may. Now, why do you think that responsible security is important in human rights due diligence? And to be honest, why do governments support multi-stakeholder initiatives in this area?
Thank you very much, Jamie, for your question here. I confirm actually our engagement in this area. I mean, as you know, Switzerland is chair of the board of the International Code of Conduct Association and is also a member of the steering committee of the VPI. There are several reasons for such an engagement from Switzerland for responsible security arrangement in the framework of business activities. Actually, other governments have the same engagement and work together on this issue. First, I don't think I could name any company active in the commodity sector that does not benefit from security services, being public or private. All extractive, I mean, being small or big, are clients of a private security company, and they can for sure play a role to ensure responsible security. Second, we believe that as a government, in the context of business activities, security is a prerequisite for conducting efficient and sustainable business. But we are also aware that security arrangements involving public or private providers represent risks for impacted communities if they are not properly managed. To that regard, in the Annex 2 of the OECD due diligence guidance for responsible supply chains, there is a clear reference to the requirement of the engagement of security forces in accordance with the voluntary principle on security and human rights. To that regard, the International Code of Conduct for private security providers could also be mentioned as a tool for the implementation of the voluntary principle. Third, at a broader level, the private security sector is growing every year. And this is not only in relation to business activities. Private security providers are working with governments in various contexts, from protection of diplomatic mission to the management of migration issues in certain cases, or in the fight against the COVID-19 pandemic. Private security providers are as well protecting NGOs in their humanitarian work and are offering security services to a large number of companies in their daily operation, especially in complex environments. That was just to highlight that security issues in relation to human rights are very important, not only for businesses, but as well for governments and NGOs. And that's why we also think that governments need to be engaged in this. Fourthly, we observe as well, as you mentioned, Jamie, before, that mandatory human rights due diligence is being considered by a growing number of governments. And in this sense, I think that having effective multi-stakeholder initiatives, developing specific standards in a pragmatic and collaborating way, but also having an oversight on their implementation can help business and governments to bring clarity on requirement, and as well to put requirements which are reasonable and which people can comply with. Now, for the last 2 days during the OECD forum about responsible mineral supply chain, we've been talking about this issue, especially in fragile contexts, and there is no doubt that security arrangements involving public and private providers represent human rights risk that needs to be assessed and mitigated. Indeed, very often, security provider is the instance with whom communities have the first contact. So when I look, for example, at mining operation, you have a gate when people come. I mean, who do they see? It's first people is security providers. That's kind of a entity people you have to go through very often to get to the company. So again, it shows it's very important to have them trained in a responsible way. To that regard, both the VPI and the ICoCA are multi-stakeholder initiatives that provide solutions to include security issues in risk assessment and human rights due diligence procedures. They offer a pragmatic framework where different stakeholders can exchange good practices, but also maintain some pressure on implementation and find practical solutions to concrete problems. For example, National Working Group of the Voluntary Principle Initiative have shown that they are able to gather different actors locally, including businesses, local authorities, and civil society, in order to discuss and mitigate specific risks related to security arrangements related to mining operation. For example, tailored solution could be found in the DRC with local communities when it comes to the access of concessions or ASM sites. On the other hand, The International Code of Conduct Association works directly with private security provider. The association builds the capacity of security provider by making available, and these are only examples, accessing to responsible vetting procedures, guidance on responsible use of force, and as well consideration on gender issues. The ICoCA also offers certification procedures, which give some insurance to the client of the security providers that measures are in place in order to prevent human rights abuses. To that regard, work with a client of private security providers is also important, and the International Code of Conduct Association can help them as well as end users to make sure that proper requirement on responsible security arrangements are made throughout the supply chain. One way for clients as well to make sure they are associated with development of standards, they are associated with implementation and with finding new innovative way, is as well to join the ICoCA but as observer of the association. As government, through our engagement in multi-stakeholder processes like the VPI and the ICoCA, we believe that we can play a leading role in promoting the responsible provision of private security services on the global stage as conveyors of different stakeholders, as donors, but also as regulators and clients. As clients. Last but not least, we would also I would also say not to forget that private security companies are often among the largest employers in fragile context, and consequently, they as well contribute to development. They must therefore not only behave in an exemplary manner, but also have access to an affordable and credible certification mechanism, which is now the case with the changes that have been adopted last year in the International Code of Conduct Association. For all of these reasons, in our National Action Plan on the implementation of the UNGPs and within our duty of protecting human rights, we have one measure which is specific to human rights and security in our National Action Plan, and we have as well another measure which relates to multi-stakeholder initiatives. So I would like to conclude with these words, and I may say, by joining the association as member, private security company can benefit from expertise, but they can as well demonstrate that responsible practices and clear clients of private security company can help us towards this agenda as well by playing a role as observer in the association. So that was all at this point from our side. Thank you, Jamie.
Thank you very much, Fred. And thank you also for highlighting the importance that the government of Switzerland gives to these issues. Before moving on to let's say the operational folk at the table, just a question to both Maura and Fred. There's always been, when one looks at multi-stakeholder initiatives, one area of criticism has been the voluntary nature of those initiatives. And by them not being binding, and I think Switzerland's a little bit different because you have in place some legislation here to make membership of ICoCA a requirement for private security providers. But is that a real, or is it a weakness at all of MSIs, the voluntary nature of these principles? Or do you see actually an added value to the nature of the MSIs, how they're structured, and the nature of the codes and the verification processes?
I may, Jamie.
To both Fred and Maura.
Okay, I can start maybe if it's fine with you, Maura. I would just say when you look at the date of the creation of the International Code of Conduct and the VPs, it's such a long time ago when we were not talking about mandatory due diligence. At this time, we didn't have as well the UNGPs. And I think we should not oppose voluntary and mandatory. Both way of working are coherent. We work together, and I think we need a smart mix of voluntary measures and mandatory regulation. And I mean, the advantage of having this multi-stakeholder initiative, it helped to develop standards. I mean, you know, it was not just the government, some people in an office writing a legislation, but it was really NGOs who had requirements. It was government who had requirements, and there were as well companies who may tell what can be done, what is achievable, what is pragmatic. So, I mean, that's a real strength, I think, of these voluntary initiatives, because we put things together, we set up a trend, we set up a standard, and after it might be followed by mandatory regulation and MSIs. I mean, they can maybe take a different role, you know, more on an expert level, developing more specific standards, guidances, and so on. I'm sure, Maura, you have things to add to this, as you are much more in it than I am.
No, well, I think Fred's absolutely right. So when the Voluntary Principles was created now over 20 years ago in the year 2000, the idea was really to create guidance for companies and other stakeholders. But the fact is, I think we shouldn't lose sight that human rights compliance itself is mandatory. Companies, individuals, people are not allowed to violate human rights, and that's true in every country in the world. But how to comport private security in a manner that's compliant? And we see it's very challenging. We see that even with public security around the world, with excessive force used. It's extremely challenging, and you put also companies in very challenging contexts or conflict-ridden places. And so I think the how to respect human rights is very complicated. It's very difficult. So this is really where I think some of these voluntary guidance-based mechanisms can play a huge role. There is, for example, we at the Voluntary Principles, we're working on special guidance now for taking into account gender and vulnerable groups. We also have a group looking at conflict, understanding conflict drivers better when companies and others do their risk assessments. So there's a lot of added value on the how, and on peer support, sharing of lessons learned. But I would say that fundamentally, I mean, human rights compliance is mandatory, and also, as Fred notes, due diligence is becoming mandatory in an increasing number of jurisdictions. So I don't see any incompatibility with having a smart mix of voluntary sort of guidance and best practices, along with mandatory rules, laws, and regulations around the world.
Thank you very much, Maura, Fred. And I think the smart mix is very, very interesting and a good way forward. I mean, we know from the ICoCA perspective that a number of clients, including governments, make membership with the association a mandatory requirement rather than simply a voluntary kind of requirement, which also, I think, strengthens that smart mix and that kind of oversight perspective. But now I'll change the tack side with nice little segues. We're looking at the practical reality of moving from sort of the voluntary to the impact. And so I'm going to turn maybe to you, Richard, if I may. So Richard Robertson, I mean, you're a strategic advisor, security services, Middle East and Africa for Garda World International. And you bring a huge experience from our discussions. It's clear that you've been in this world for quite a number of years and have a lot of practical know-how as to, you know, what do the issues look like in country and on the ground. So I've got two questions, slightly different tack to the broader questions I gave to Fred and Maura. And the first one is, you know, given your experience in both large-scale and artisanal and small-scale mining in conflict and high-risk areas, how do the VPs and ICoCA assist civil society and private sector supporters of responsible LSM and ASM? And the second question, you know, is looking at the artisanal side, you know, what challenges in the ASM sector can be addressed with VP government and ICoCA private sector support? Because much of the discussion has been focused on the large corporate entities and not on the artisanal mining elements. So, you know, is there a role for the VPs and ICoCA in that regard? Richard, the floor is yours.
Thank you, Jamie. And let me share a bit of an anecdote to start on this voluntary versus mandatory question. For 4 years, I was the managing director of a tin mine in a former war zone, in a previous war zone of North Kivu, Alpha Mine BCA Mining. And at one point, we were engaged with financiers, including the IFC, of the World Bank, who essentially told us that we would need, given the risk we were in, surrounded by armed groups, a public sector security service that was known for not being well paid or underpaid, and sometimes exacting human rights abuses on the population. And we were sitting next to 1,200 artisanal miners who were actively working our concession. So the IFC said, well, if we want to move ahead, you need to join the voluntary principles. And so Alphamine joined the VPs and remains a member of the voluntary principles. And I want to share with the audience that this is not just a paperwork exercise or compliance exercise. It's a good way to do business in a high risk environment, because the voluntary principles gives you the orientation to engage with the community and to approach problems with a long-term perspective, which cannot be solved without respecting human rights. Ironically, we were not successful in negotiating IFC participation in our project, not for human rights reasons, but for technical reasons. So they mandated it, and then they walked away from the deal. So, but I want to, I've had a rich experience over about 20 years in the DRC, particularly to work for an international development NGO, PACT, that is a member of the voluntary principles. I've worked for 2 different private mining companies, for USAID in the conflict minerals development area. And now I'm advising GardaWorld, a private security company. And I think it's important that we understand that, as I said, ICoCA VPs can begin to be a way of doing business. I've been comforted and impressed that the company I'm advising, GardaWorld, when frequently asked by traders in the DRC to secure and assist in transporting artisanal gold from one place to another in the Congo and then on to another second and then third country, says no. That's because GardaWorld doesn't know the customer. They don't know where the minerals and the gold came from. They don't know what's been associated with the processing and with the financing of the artisanal production, or who's making money from it. And so the VPs and ICoCA begins to be a way of sharing common objectives with end users, with responsible private sector, and with local civil society and government. At a large copper and cobalt mine where I worked previously, we were attacked by artisanal miners at one point, who were frustrated by not having continuous access to the ore body legally given to the mining company. Beyond our control, the Congolese army was dispatched by the provincial governor, who had learned from previous human rights mistakes of companies and himself, and he signed a written requisition following a procedure to mandate that there was time for the army to control the situation. As the army entered the town where we were located, and as they entered our base before they went out and did for their deployment, we read the voluntary principles in French to the military, to the soldiers and their officers, and we gave them copies. And we documented that we did that, not just for purposes of future-proofing our credibility, but also for conveying to these public security agents that our future depended on their responsible behavior. We provided food so that they would not be bothering the local population. And after several days, peace was restored in that community. At Alphamine, where I worked for 4 years, we were sitting side by side with artisanal miners on our concession who were armed, who were using unofficial dynamite, who were abusing their fellow workers or children by force to mine the tin of our ore body. And as we documented this situation to the Congolese government, repeatedly in every letter where we asked for help, we made clear that we had to request their assistance that would be consistent with the voluntary principles, that we couldn't allow them to come in and help us in a way that undermined our reputational risk and our human rights legacy. After several years, we were successful in negotiating the peaceful departure of 1,200 artisanal miners without any force, without any tear gas, without any weapons being used. There were arrests, and those were for cause and have held up in court, in legal court, but also in the court of public opinion for cause. So I want to share also with those in civil society and end users that members of ICoCA are concerned that we reach out and work with local civil society organizations, and recently with DCAF and with the OEAR SE organization, we ICoCA identified with members of ICoCA. By the way, ICoCA has not only governments, it has private security companies as members. It also has civil society organizations throughout the world involved. And these are in local communities nearby where artisanal mining occurs, often without formal operators, and are ideally situated to be a resource. With these civil society organizations, we identified the conditions that have already been alluded to that need to be addressed as human rights concerns: insecurity, dire working conditions, poor selection and vetting, lack of transparency about who owns the company, and providing all the information that allows clients down the supply chain and observers in the community to conduct due diligence. Training needs to be provided because, as Frederick pointed out, these are the first contacts that visitors, the community has with artisanal or large-scale mining. There's often little respect for international standards on human rights. And it's often confusing what the mix is and what the roles are between public and private security and company security in the case of companies. So all of these are issues that responsible private sector security companies share with local civil society as issues that need to be discussed and worked on.
Thank you.
I'd like to turn specifically to the ASM.
I'll ask you to wrap up in a second or two if you wouldn't mind, and then I can always catch up with further questions if you want afterwards. But keep going. I interrupted you. I apologize.
Sure, that's okay. Just to say very quickly, I think as we look at the non-formalized ASM sector, there are challenges for private security in that the client doesn't exist. The client are artisanal miners, cooperatives, exporters, and it calls on private security to rethink how it approaches these networks and maybe works with networks rather than specific companies. And as initiatives are formed to responsibly source artisanal products from Katanga and cobalt or the 3T and gold from Eastern DRC, the issues of security, transport, vaulting, escort, and risk assessment, which is an area of capacity for the private sector, may need to be delivered in a different way. So I'll stop there. Thank you.
Fantastic. And apologies for cutting you short. I mean, the difficulty we have is there's so much there, and it's very, very rich. And hopefully we'll come back to some of these points. But certainly, I think the point you made there about we don't know who the customer is. So I'm now going to turn to the so-called customer, the client as such, to Mandla Zembe, if I may, who's the head of protection services at Anglo American Platinum Limited. And thank you very much for coming on this webinar. I know we've been trying to sort of chase you down and you're out in country. So I'm glad you were able to come back and be online. So very much, building on the comments from previous speakers. And you've heard especially also the comments there from Richard about the responsibility of clients, so the artisanal mining side of the house, the local communities and CSOs. Now, what steps, practically have Anglo American taken to identify and assess risks associated with private security? And by private security, I like to sort of also emphasize both the contracted external private security, but also in-house security. And what steps have you taken to develop strategies to address these? I know the floor is yours.
Thanks, Jamie, and greetings to all the colleagues on the line. Due to time constraints, I'm just going to lick the lollipop and I'll take the questions thereafter. So just to give a brief context, Anglo American is a big conglomerate which operates in many areas in a violent environment, with issues ranging from community unrest, people demanding a lot from the mines because the government cannot deliver in various countries, to issues of violent criminal attacks. What we therefore did is to employ a hybrid system of both internal and external service providers. However, I must make emphasis from the beginning that we hold both institutions to the same standards, meaning what applies to the goose must apply to the gander. As much as we normally deploy our own internal security to high-risk areas because of various factors such as prevention of collusion, better pay, salary, training, and all those kind of things, more incentives compared to the outsourced service providers. And we also deploy then the outsourced service providers in low-risk areas. However, the emphasis are still the same. The requirements are still the same. The due diligence that we do is still the same to all parties. However, for us to ensure that, like you said, the client must ensure that, because there are many risks associated with appointing an outsourced service providers that does not belong to you. They can come and ruin your brand, your reputation by the manner in which they handle this community unrest and these violent attacks that are happening in your operation. Hence, it is very critical that you know who you are dealing with, and you have command and control over what they do, that rather than just appointing them and leaving them to do as they please. So there are strategies that we've put in place to ensure that we are not found wanting in this regard. We conduct a serious due diligence for private security in addition to public security, which is a subject for another day. And during that process, we conduct an in-depth investigation and analysis of the potential service providers that we want to appoint on our sites, so that we can be able to ensure that the people that we appoint are the people that are going to live the values that we have in the company to promote, protect, observe human rights in the manner in which they deal with issues, obviously following the protocols that are in line with legislation and protocols in a particular in-country. We provide serious guidelines to the supply chain to ensure that the people that bring on board are conformant to all the requirements that we want in terms of the values that we have in the company: safety, care, and respect, but also most importantly to ensure that they protect, observe, and promote human rights. In addition to the supply chain process, we've got our own in protection services, private security due diligence, where we investigate on our own. We go out, we gather information from various sources in order to ensure that we know who they are, where they come from, what is their vision, what is their history, who their clients are, where have they operated before, how did they perform, are there any issues of concern that we need to really take note of, because we must prevent bringing people on board that will bring us into disrepute. But in addition to that, one of the strategies is to bring in an independent party. We appoint an independent third party that will come and scrutinize our own security as well as the private security, for us to obtain an independent and objective view as to whether we are indeed complying to the International Code of Conduct for Private Security Services, whether we are conforming to the Voluntary Principles on Security and Human Rights, and whether we are conforming to any legislation either internationally or locally in a country where we operate as it's required. It means that we conduct a detailed assessment to ensure that objectivity and independent information that we get. We conduct screening and vetting of not only the company, but the directors of the company, as well as the individual security officers that we'll be bringing on our site. We need to understand who they are. The majority of our members internally and those that are joining private security have got military background like myself, and others have got police background. Some of them could have left the service for the reasons that really we need to take care of so that they cannot come and abuse human rights. So we do that screening and vetting process. And then we also make sure that there's a service provision where we entail and write and detail everything. What is it that is expected of them in terms of the voluntary principles, code of conduct, and so forth. And we do that by ensuring that there are clauses that we bring to their attention even before they pen their signature on the block and the service level agreements to say they will observe and abide by as soon as we do business with them. But in addition to that, another strategy as well, we work with NGOs that are independent, such as International Alert, who come and scrutinize our policies, procedures, protocols, systems to see whether indeed also they are conformant in ensuring that we comply with the International Code of Conduct, voluntary principles, legislation, and so forth. Because you get also an independent, and you know NGOs, they are not holding any punches. So they will scrutinize you from left, right, and center in such a way that we ensure that we indeed comply. We check the clientele of the private security. We ensure that we find out what type of training that they do. Is it in line with what we want to do? Is it not something somebody special force from somewhere with adrenaline? All that he wants to do is just to ambush the communities when they protest against the mine. We ensure that there's compliance to in-country specific legislation and regulation. In South Africa, for instance, they require that you must do a psychological assessment of your security to make sure that whatever they do, they are mentally correct to deal with human beings as they come to the site. And also they observe other regulations, like when you search people, a lady must search a lady, a gentleman and a gentleman, and you don't abuse the human rights and so forth. We make sure who they are registered with, who are they affiliated with? You know, are they known by the voluntary principle or by ICoCA, for instance? Do they adhere to that code of conduct in the industry? Do they adhere to the UN business principles of the use of force and firearms, for instance? Do they know them? Did they get the training? And additional strategies that, in addition to the training that they claim to have, we give them our training even before they set foot on our site. We give them and after screening, we give them an induction, and then we give them training again to ensure that even tomorrow when we can go to court, we can have a record to say, you know what, we've done things right. This was a situation beyond what any normal or reasonable company would have done. And as I conclude, we also conduct a refresher training every year for every individual, whether internal or external. If you have not missed your refresher training, you are taken off site until you've conducted your training, and then you are brought back on site. And then we also make sure that there are ongoing reviews of the company and of the employees in the company. It means it's continuous screening, because after you've screened them, when they come in during initiation, they might go and do something else afterwards, which they might not report. So you need to always go back and check whether they don't have criminal records. There are no cases pending against them. The companies have not violated human rights elsewhere in order to ensure that you do that. And as a point of departure, we also conduct ongoing evaluation and monitoring of the supplier integrity. We conduct benchmarking in order to ensure that we utilize best practices through VPIs and ICoCA and other institutions. And then we created a desktop for record keeping for compliance. As soon as they don't comply, we make tick boxes. We hold our meetings, we call them to order. It's either they comply or we let them loose. But other than that, we have our daily and monthly engagement meetings to make sure that indeed there is that continuity and compliance. And finally, we conduct our annual review and assessment and report to the Voluntary Principles Initiative report, which Maura is the custodian of those reports once we've given to them. Where we've done wrong, we admit, and we also state what corrective measures we have taken. and what we do to prevent that from happening in future. And then we've done right, we also raise our hand and say, you can learn from us. Thank you.
Thank you very much, man. Again, similar to Richard, very, very rich. I mean, it's a shame to cut you guys off too quickly. We have a question that's come in here, and maybe I'll turn it back to this first question would be to, I think, to Richard and Amanda in particular. So the question about multinational private security companies. So I think both of you have spoken about the sort of the local footprint and the local vetting and the background checks. But what if you're dealing with a multinational security company? How do you do the follow-up there? Where should liability sit? I'm not going to sort of unpack the whole question, but just maybe first to Richard, looking at that question that's come through, and then maybe Manla give you a pause to think about that one too, before I come to you and Maura, Fred, about questions of grievance mechanisms and remedies and what those could potentially look like. Richard, if you want.
Yes, I think some of the responses can be highly technical, and actually I would defer to others experts, but I can speak to the general coverage of a company like GardaWorld, which is the world's largest privately held security company. We have 102,000 employees throughout the world, and broadly, we are covered for human rights under our ISO performance standards, as well as our ICoCA membership. However, the certification from ICoCA is specific to countries. And so for a question that someone has in terms of GardaWorld or someone else who's a multinational security company, it's relevant to ask the question, do you have certification for this specific jurisdiction and country? Because ICoCA certifies for specific countries' operations and so on. At the same time, some of this coverage and some of the policy issues are set up across the entire company, and that covers to a certain extent. So I'll have to stop at that, Jamie.
Excellent, thank you. And Manla, just follow up on you. I mean, we'll may go over the hour by a few minutes if you're okay with that. Similar question. I mean, if you're doing your vetting as a multinational corporation yourself and you're involving international companies, how far do you go in terms of jurisdictional reach?
With us, we go as far as possible, because platforms like this one, it's where you network. It's where you meet consultants and institutions that can help you with further due diligence beyond what you can do. We have an office, our group office in London, and we have a third party that we work with that may even be able to find, I think everybody would know that if a member has served in the defense or in the police, normally some of the information is classified and becomes difficult sometimes or cumbersome for an ordinary company to access that information. But there are institutions and companies and consultants that are able to dig deeper for us, just to make sure to cover all the bases, that the people that we appoint and utilize really are people that are genuinely for the protection, promoting, and observation of human rights. So we utilize third parties that have got that capacity to do that for us, in addition to those that we can do ourselves, because locally we have access to the military, to the police, we've got contacts, we work with them, we've got forums where we meet and be able to share information and get those. So, but in terms of multinational companies, that's where now you go to third parties, those that can get more information than what is in the public eye.
Super, thanks. And I mean, so yeah, from the association perspective, of course, we carry out rigorous monitoring of private security company members as well as non-members if clients want to do that. So I think what you referred to, Mandla, about bringing in organizations like the VPIs and ICoCA to help evaluate, carry out the human rights due diligence can only be beneficial to the clients and so on. Fred and Maura, I'll turn to you. The question of, it's similar to the question of accountability question we had a few seconds ago. And it also, I think, piggybacks on the voluntary aspect of these multi-stakeholder initiatives. Another, I think, area that one looks at is the question of sanctions. What if someone does something wrong? What if one of the companies, one of the members of the VPIs, or one of the members of ICoCA, violates the code of conduct or violates one of the principles under the VPIs? Potentially, these are criminal issues. And what are the sanctions which potentially are out there? What are the grievances and the grievance mechanisms which are available to individuals being harmed by those respective companies? And is there a gap somewhere in terms of the accountability, impunity piece? Maybe Fred first as government and then to Maura?
Yeah, thanks for this very difficult and embarrassing question. I would say, yeah, I mean, there are gaps, obviously. There are gaps in certain countries. I mean, of course, like in Switzerland, if there is some human rights abuses, I mean, the victim can go to the official court and fill in a complaint. After, the question of the activities, for example, of multinationals that are based in Switzerland and may risk to commit some human rights violation abroad. I mean, that's a difficult question. And in principle, I mean, the solution should be in the jurisdiction where the violation has been committed. After there are some, I mean, like this whole due diligence, mandatory due diligence debate, which may change this. After, I mean, governments like Switzerland, I mean, we encourage, I mean, through participation in these multi-stakeholder initiatives, I mean, like the ICoCA, to set up grievance mechanism. I mean, for example, the ICoCA is this grievance mechanism in place as well, where victims can raise a complaint and then it's being treated. After, I mean, there is maybe not a hard due diligence law as well in Switzerland. I mean, that applies abroad, but after, I mean, there are still messages like our Federal Council is telling to companies, I mean, publicly, that he expects Swiss companies to respect human rights wherever they operate. And to that regard as well, I mean, private companies active in the commodity sectors, NGOs and government, we have issued guidance. It was 5 years work almost, because we worked together. We issued a guidance for the implementation of the UNGPs throughout supply chains of commodity traders. Maybe I can put you the link to this document as well on the chat.
Yeah, no, definitely. Thanks, Fred. And Maura, likewise, a bit of a tough question in terms of the sanctions, grievances, remedies if something goes wrong.
Right. So I think, I agree with what Fred said. Certainly if if a human rights violation rises to the level of a crime, obviously that should be investigated by local authorities and prosecuted properly. In terms of other kinds of remedies, if a perpetrator is a member of the voluntary principles, there is an internal grievance procedure. I mean, the worst that could happen is that a company or another perpetrator, no NGO, for example, could be expelled from the initiative. So I think we need to look at other kinds of remedies as well. I mean, that's obviously there are huge limits to what a voluntary membership-based initiative can do. I know I think Fred was talking about the home state. So for example, there are some remedies limited, courts, for example, but also things like an ombudsperson in Canada that could seize jurisdiction over an issue, and increasingly they have done so. But also, and maybe I'll just say this in my own personal capacity because it's not really a voluntary principles issue, but I think as a lawyer that companies should also settle disputes and settle harms that they commit. I think it's just the right thing to do. As a lawyer in Canada, I can say well over 90% of legal actions are settled, in which the plaintiff, it receives some kind of compensation, and there's a settlement, possibly an apology for the harm done, and some recompense. And I think that a reasonable and just settlements are the right thing to do as well. And this can certainly be done pursuant to a grievance mechanism, which, as Fred noted, is required by the UNGPs. Thanks.
Excellent, thank you. I'm man the time. We're on the hour mark, so I'm going to actually put out a bit of a catch-all question to the four of you and go in reverse order. So we opened the discussion here to talk about approaching the 10-year anniversary of the implementation of the due diligence guidance for responsible supply chains of minerals from conflict-affected and high-risk areas. A bit of a long title. We marked, I think, is it the 20th anniversary of the Voluntary Principles Initiative? and we've also marked the 10th anniversary of the International Code of Conduct Association. So and I think most of you have been involved in this world for a number of years now. So my simple question will be, starting with Mandla, and you have about a minute and a half to answer. Based on everything you've seen so far and the progress in this environment, what can be done better?
I think more cooperation and collaboration will go a long way, especially between the two leading partners, ICoCA and the voluntary principles, and bringing in more specialists and providing more platforms like this, where we can engage and even maybe not within an hour, maybe have 2 to 3 hours, where we can be able to know who's on the line and how could they be of value to this. Because it is through engagement and networking and working together that we will move from one level to the other. There is a lot of innovation out there, but it's left untapped. The more we open platforms, the more we'll be able to tap and do better. We have done better already compared to what was and what is. And congratulations to both institutions so far. And I think we can still go a long way in leading this environment. Thank you.
So collaboration, cooperation, and more time, and also bringing in more people as part of the discussions. Richard, same for you. I mean, what can be done? Where are the improvements still needed? And I think you touched upon especially the ASM piece, which is a big topic as well. There's a question that's come up there. So you have a minute and a half to try to sort of, come up with a recommendation of what can be done better.
I think civil society can really take on the opportunity to market themselves to be of value to the responsible private sector who need their help to do community assessments, to do the things Mandla discussed, where you bring in a negotiator or a mediator or an expert to investigate a certain situation. So make yourself valuable to the private sector. Nobody wants misery and human rights abuse to be the result of their business activity. And so I think the other suggestion I have is that ICoCA, the voluntary principles, become more accessible to more governments. So it's easier for governments to be associated to the VPs and ICoCA to be, ICoCA is available, is ready, it can go down to a local level with local service providers in throughout the world. And but to encourage people to join so that they see ways to benefit from the voluntary or mandatory nature of these agreements, because it just makes business sense to be more secure. And the best way to be more secure is to be in good relationship with the people around you, the people that work for you, and the people that need and rely on you for for paying taxes. So those are my suggestions, Jamie.
Thanks, Richard. And I'll definitely take, I think, the call out for civil society to be more engaged, and for more governments likewise to be engaged, and not to be looking only at the clients and the corporate sector as such, but looking at the other entities which are key to ensure we have a sort of safe and secure environment. Fred, from a government perspective, same question. What can be done better after these 10, 20 years of experiences that we've had so far?
Very difficult question. So I'll just propose a couple of elements. What comes to me is that this debate, mandatory due diligence, voluntary measures, human rights and security in fragile contexts, it has been very emotional. I mean, we saw this with a popular initiative last year in Switzerland, and I think this is not good. And we should really think about facts, analysis, and pragmatism. What I think, if we really want to have things progressing is to reach a level playing field. And I think like what is done within the OECD, the VPs and the ICoCA, I mean, that helps to reach this level playing field and to build standards that will be accepted and acceptable for everyone. So that's one thing I would recommend. And while doing this, I think as well that creating bridges, I mean, for example, creating bridges between regulators, company and civil society is very important to make sure that we get pragmatic solutions that has a positive effect in the field. And of course, we should never forget the local level. I mean, you know, a mining operation in the DRC, I mean, it impacts a lot of people, and they may as well have their word in finding solution. And that is something we sometimes forget as well.
Thanks a lot, Fred. I mean, level playing field, creating bridges, and having that kind of discussion as well that we're striving for. So, Maura, as co-host and VPIs, so the last words are yours. What can be done better? You'd have to unmute on that one. Yep.
Sorry. At risk of sounding incredibly repetitive to what everyone else has said, I really support the other comments. I think a key is engagement, especially engagement on the ground. Who are our ultimate clients? I mean, they're the affected communities. They're the people who bear the brunt of the extractive sector project and really hope to see the benefits. And I think you know, those communities are key. And how do we reach them? How do we make sure we reach them on the ground? It's very challenging. I mean, for sure, civil society plays a great role. We have these wonderful working groups that are supported, some by the voluntary principles, some by groups like DCAF that do great work on the ground. And I think this is an area that we really want to and need to expand on, because these groups are multi-stakeholder. They're often supported by governments like the Swiss government, which has done great work in places like Nigeria and the DRC. And these groups can reach out and be the sounding board. They can understand the problems and work on mutual solutions. They can help with the risk assessments and the due diligence. They can be the eyes and the ears of the community, and really link right up to the international level ultimately. So I think I mean, the world needs more security and human rights work, that's for sure. But I really agree with what everyone said, and hope that we can keep moving forward on greater engagement and support for these groups on the ground.
Thank you very much, Maura. So the local engagement, the local level work in particular was emphasized there. And I would also add sort of the end user part as well, the pressure points. I mean, we're mining for a reason and to produce something. So the end users likewise should be looking at these issues more closely. I apologize to the panelists and the participants. I think each of you could have spoken for the best part of an hour on your respective topics. And I'll take Manda's recommendation that we should have more time and more webinars and more discussions to speak of these things. Those questions which are not answered, I think we'll try to get them in a written form. But bearing in mind the time we're at right now, all I can do is thank Maura, Richard, Fred, and Mandla for taking the time out today to brief on your experiences, share a few wise words, and come up with a couple of recommendations in what was a quite tight schedule. And so for all the participants, thank you for being with us, and I wish you all a good evening. Good night.
Thanks to all of you.